Hi, listeners. Welcome to COPA's Navigate Ed podcast. I'm Denise Marshall, mother, grandmother, COPA CEO, and your host for Navigate Ed. Bring a passion to the quest for equity in education that's born out of decades of lived experience. If you're not familiar with COPA, our mission is to protect and enforce the legal and civil rights of students with disabilities and their families. COPA believes that the effective educational programs for children with disabilities can only be developed and implemented with collaboration between parents and educators as equal parties. We have over 3,400 members in all 50 states and several territories. We reach tens of thousands each week through our networking, training, COPA news, and social media. We invite you to join us, and we'll talk later in the podcast about how to do that. Today, I'm very excited to have two guests with us for the session called The Road Ahead: What We Know and What to Watch. We will review anticipated changes within the new 119th Congress and the administration, and we'll share information about key players and issues, as well as potential potholes. Special emphasis is on explaining the potential impact of the Loper case, the case that overturned Chevron, and what that may mean for or may not mean for existing regulations. So I'm very pleased to have with us today the first of our guests, who is Laura Kaloi. She is COPA's federal policy advisor and has decades of experience in protecting the rights of students with disabilities and their families at the federal and state levels, but she works at the federal level for us now. And Laura, it would be helpful if you could introduce yourself to the audience and tell us a little bit about who you are and what you bring to this work.
Hi, Denise. Really excited to be here today. Thank you for this opportunity. I have worked with COPA since 2013, and it's my honor and privilege to help lead and work with you and the board and our members to advance the agenda for students with disabilities and their families in Washington, D.C. I came to this work in about 1999, working for the National Center for Learning Disabilities as the policy director there. And along that journey with a husband with dyslexia, have a now grown son who also has dyslexia and dysgraphia, and merged my role as both a advocate and a parent advocate, and have really pleased to be able to support my own child and to help him navigate his educational journey and opportunities. I am excited to be here today and look forward to what we're going to discuss.
Great. Well, thank you. Thank you for all that you do for COPA. You're an invaluable resource for us. So today, I really want to focus on the difference between laws and regulations and kind of how that process works and what, because it plays into, I think, what we can expect in the next incoming administration and potentially that of Congress. So, could you kind of start off telling us what the difference between a statute and a regulation is, maybe with some examples of some of the key laws that we function under in the education space?
Sure. So, Congress passes the law, and that becomes the statute for a major piece of, federal policy. So in our country, we have essentially four big education laws. We have the Individuals with Disabilities Education Act. We have the Elementary and Secondary Education Act. We have the Higher Education Act, and we have the Section 504 underneath the Vocational Rehabilitation Act of 1973. Those four big laws help give the construct to both educational access, opportunity, accountability, and to protect and to prevent discrimination. Regulations sit underneath each of those statutes to help implement those laws. And IDEA is set apart from those other laws in this way, in that in the 1980s, that it didn't really make sense with IDEA to have the regulations sit outside the statute and be open to interpreted by different administrations that come and go with elections in our country. And so the regulations for IDEA actually sit inside the statute. Congress put them together, tucked them in there, and have essentially left that intact. Even when they've opened up the law to amend it, they have allowed and make sure that those core regulations that go with the core pillars of IDEA are wedded to the statute. So they're one essentially one piece of law. And even though the regulations, can be interpreted in some ways, it's different with IDEA because Congress has been very clear that the administration can't play with those regulations. Other laws, like the ESEA, which is the big Title I law, those regulations can be interpreted and looked at by each administration that comes in. And sometimes administrations make changes to regulations and reinterpret the law. Is that enough to get started?
Yeah, no, that's a mouthful for sure. It sounds complicated, but in essence, I think what you're saying is that when the Congress passes the statute, then the administrative agency, whoever that might be for the majority of laws, can reinterpret the statute and pass the regulations, which become almost the recipe for how the laws get implemented at the local and state levels.
Thank
Um,
you.
eh, yeah, so just using that restating principle for education of talking it through. So yeah, and I think I think one of the key points is that only Congress can make the law, and that at the federal level. And that's true at the state level too, but it's the state elected body that does that. But in Congress, at the federal level, they're the ones that pass the laws. And most of the time, it's the administrative agency that handles the regulations, with the exception of IDEA, as you said. So, in relation to the Congress being new, the 119th Congress, let's talk about what we know so far and what we should watch for as things unfold.
Sure. So there are a few things happening on parallel tracks. Congress gavelled in on January 3rd, meaning the 119th Congress is in fact underway. Despite that, the president will not be inaugurated until Monday on January 20th. And so the Congress does function separate and distinct, as folks might remember from your eighth grade civics class. That is the difference between our legislative body and our executive branch. And so Congress is underway. They have organized, and a couple of things to point out. The first one is that we have a new chairman in the Senate Health, Education, Labor, and Pensions Committee. We call them HELP for short. Senator Cassidy from Louisiana, who was the ranking member, is a Republican. And because the Republicans have a majority in the Senate, will now become the chairman. And so Bernie Sanders, who's been functioning as the chair until January 3rd, will now be the ranking member. And so they've switched roles in that way. And will now the agenda in the Help Committee will be set by Chairman Cassidy. And we know that he is a medical doctor, very interested in dyslexia and literacy, are kind of his priorities related to issues that we focus on. We also know he's an advocate for school choice and voucher funding. And he has some focus on higher education. And then, of course, it will be a health, focus to his work because of his interest there. So we'll see what he puts forward. But the first thing he's responsible for is the nomination hearing for President-elect Trump's nominee for the Secretary of Education is Linda McMahon. And so we're waiting for the committee to schedule that date. But he said it's coming soon because her paperwork is in place. And so we're watching that really closely. And in fact, COPA submitted some suggested questions to the committee, and we'll see what takes place at that hearing. We don't expect her to be highly controversial. And it does appear that she will be able to get the confirmation that she needs from the US Senate. And then
What do we know? Anything?
Well, that's a good question. She has been very involved sh- in her work related to school choice, vouchers, etc. She comes from the business world. She and her husband are very involved in the Worldwide Wrestling organization, and she comes from Connecticut. She served on the school board there, I believe, for about a year, and she's run for office there unsuccessfully a couple of times. She has served for former President Trump when he was here before as the administrator of the Small Business Administration. So we know she's a business person and has promised to carry forward the agenda related to reducing the federal footprint, spend, etc. And we don't yet know a lot about how she will implement that agenda once she's at the Department of Ed.
Okay, great. Thank you. Well, speaking of the Department of Ed, one of the things the media keeps reporting is that the new administration plans to close the Department of Ed. First of all, can you remind us what is the Department of Education charged with under the law? What do they do?
So essentially, they are here in DC. They oversee the dispersal of the formula funds that come through our big federal laws. Title One, as I mentioned before, is our general ed funding law, and IDEA. Both of those are big formula funding programs. And then there is money that flows to states for higher education and for school lending to help, students have access to post-secondary education and then other programs. But they also serve through the Office for Civil Rights to protect and discrimination against students in K to 16 settings. So they do also have a major, including dispersing the funds, they have a monitoring and a compliance and an oversight role of those laws that Congress has articulated through these various statutes. And that's the role that they play currently. And it's a big job. And, you know, it was the Department of Ed, I think, was founded in the mid 1970s, and they've been functioning ever since.
Okay. Thank you. I know I've seen people have asked, what would we really lose if the Department of Ed, say, was closed and some of the functions were moved over to the Health and Human Services, for example. And I personally have said I think that we lose two things. One is expertise around the teaching of students and students with disabilities in particular, and also the potential loss of the Office for Civil Rights, which functions under Ed right now and is one of the only bodies that has really been active in that enforcement and making sure that students have equal access and benefit from their education programs. I don't know if there are other things that you think immediately would be a big loss by closing the department, or what it would take to actually close the department. That's a realistic quest.
I think that's a good place to start. Congress has to agree to make that happen. The president can't decide that, nor can a secretary of an agency decide to close down a federal agency. That is a decision that the US Congress would need to make. A vote was taken on that in 2023, and 60 Republicans actually voted against it at that time. And given that there's only a two-seat majority in the House, the political likelihood there appears, squishy, at least. And in the Senate, it's even more unlikely. The Senate, you have to have a 60 vote majority. You have to have 60 votes to pass something like this through the Senate. And where they only have 53 votes, they'd have to pick up 7 Democrats to make that happen. So it seems unlikely. They also have a pretty aggressive agenda on other fronts, including for taxes and some other issues that they want to focus on, and whether they want to expend their political capital, focused on the Department of Ed is a really big question.
Okay, so it's possible that rather than see it close altogether, there might just be a diminishing of size or scope or impact. But all of that is part of the unknown right now.
It is. I think we know that COPA, one of the things we will be watching closely and working with our allies to pay attention to are any reinterpretation of regulations. As you mentioned, we'll want to pay attention to anything. They must follow the Administrative Procedures Act and go through the process to change regulations, but we will be keeping an eye on that. The federal budget will be proposed, including for funding for education programs in anywhere from 4 to 6 to 8 weeks, depending on how fast they turn around a new proposed budget from this administration. And we'll be looking at the funding levels and that is where we expect cuts to education programs that we care about. Historically, even the proposal that the Republicans made in 2024, there haven't been significant cuts to IDEA in particular. However, we do remain concerned about the programs that live around it because students with disabilities are general education students first, and all of that money really matters. States rely on those monies in their budgets, districts need those monies, and we advocate for other programs in addition to IDEA. And we will have a lot of information on that as things start rolling out this year.
Okay, great. What are some of the other key issues that you expect will be focused on in the early days of the administration and or the Congress?
Well, it's interesting. Today, the House Education and Workforce Committee, that's the committee with jurisdiction in the House on education matters, they had their first organizing hearing today. And new chairman Tim Walberg from Michigan said that I'm going to quote, he wants to pursue education policy that addresses college affordability, expanding school choice, and holding accountable schools that allow anti Semitism to run rampant. And he says he's fully committed to President Trump's agenda on education. So that sets up how he wants to lead his committee. And then ranking member Bobby Scott, who is a served as a long-term ranking member from Virginia, chimed in and said that he hoped they could start with the bipartisan work they did just finish in that committee on the Workforce Investment Opportunity Act. And while that focuses on employment, COPA does pay attention to that because vocational rehabilitation lives inside that law. And we, of course, care greatly about what transition opportunities look like for students with disabilities into career and technical education, STEM careers, and post secondary opportunities, including apprenticeships, et cetera. So it'd be nice if they started with something bipartisan, but we'll see.
Any other issues? I know that there's been a lot of talk about the issues of trans athletes, which is tangential to COPA, but includes gender identity and pronouns and just a lot around house in general. But of course, there's an intersection, as you said earlier, between all students and their different identities and students with disabilities. Is that expected to gain steam in this administration?
Well, this a bill that would prohibit transgender from participating in female athletics passed the House of Representatives. And so it's been sent over to the Senate. Again, this will take a 60 vote count to pass in the Senate. And so there's work being done by those advocating for that law to pick up some Democrats. It's not likely this bill is going to move quickly, but there will be contemplation and discussion and, some consideration in the Senate for it. So we'll be keeping a close eye on it. The intersectionality for children with disabilities in all of these issues related to LGBTQ issues are students that have language, literacy, poverty. There's an intersection here with vulnerability, right? Bullying, harassment, all the issues that we know can impact student success in school. And so we do work closely in coalitions and with allies on all of these issues.
Yeah, great. That's what I was just going to say, that I think it's a part of the larger school climate issues that COPA works on. Again, although we don't have a specific policy position on athletes per se, but we do look at whether or not students are discriminated against within the school environment and that bigger picture of whether the environment is a hostile environment for them to participate in, and other issues that play into the school climate arena, so to speak. So, what about some of those bills that COPA has really been pushing for, such as the Keeping All Students Safe Act and other issues around the school climate and school safety? Do we have any idea how or if those might move forward in this 119th Congress?
So we know that our sponsors, and we do work on the Keeping All Students Safe Act. We are the lead with the ARC. We run a coalition that focuses on eliminating the use of seclusion and preventing and reducing the use of restraint in schools. That bill and its suite of bills that focus on corporal punishment, the push out bill focused on girls of color in schools, other bills that focus on mental health and school climate issues, and also eliminating funding to school districts to hire police. Those bills are all going to be reintroduced, and we don't yet know the schedule of that. But we will be working with all of our partners to support and lead on those issues in the next, for, I would guess, in the next 8 to 10 weeks, we'll start seeing those bills rolled out.
Great. Can you explain a little more why organizations like COPA are pushing for police to be removed from schools?
There is tremendous evidence, and it's not just research, it's quantitative, qualitative, viable experience, lived experience of students and their families for the harm that school resource officers and police presence in schools bring to children of color, children with disabilities, and again, the intersectionality of any of the issues that we know might impact a student's opportunity or their access to an education. There is an increased likelihood, if you're a child with a disability and there are police in your schools, that you will be misunderstood, that your disability is not known or recognized, and that you have a higher propensity to be, restrained, referred directly outside the school to the police, shepherded out the school without your parents even knowing that you've been taken to a, to the police. And also just this use of these threat assessment systems that are not attuned to the unique needs of students with disabilities. Of course, we want schools to be safe places, and we want schools to be an environment where children feel safe and can thrive with building those relationships that they need with the adults in their lives in a school. And we want the adults to be able to have the tools and resources they need to educate those students and to support those students. So we're promoting, rather than police, having access to those funds to create and support school teams that support the mental health, the social and emotional learning, multi-tier system of supports, thinking about restorative practices and how we help support these students in schools really becomes the focus of what we'd like those dollars to do.
Great. Okay. Thank you. I think that's helpful for people to understand because we hear from a fair amount of people who say, "Oh, the school resource officer in my school is a great friend to our child, or to has been helpful." And we certainly are not discounting that kind of experience happens. But as Laura said, unfortunately, the evidence is quite high that students of color, students from low economic means, and students with disabilities end up having a very different experience and are often pushed out of the school, handcuffed, taken down to the police station, suspended, expelled. The list goes on and on. So we're wanting dollars to be focused on preventative and educative types of interventions for all students that are shown to be effective. And I guess, Laura, the last big issue that we know is coming down the pike or has been building momentum for a couple of years is the issue of school privatization vouchers, school choice programs, and COPAA. This is another issue that we do not have a specific policy that against school choice or against voucher programs per se. However, we have done a lot of work around making sure that people understand that a lot of those school choice programs come with a price tag, and the price tag is sometimes monetary in the sense that families need to supplement whatever is given to them by the districts, or they need to provide transportation or other kinds of services that the school no longer provides. But also, a big price tag is the loss of rights, and that schools often skirt their obligations to students and families by giving the money directly to the family, and the family then gives the money to the schools. And so the big winners sometimes in this scenario are the schools, and families are often, from what we've heard from our members and what we've seen in the data, ended up counseling out or being expelled or losing services and needing to go back to public schools, at which point there's been a significant delay and they've have to reapply and start the process of eligibility all over again. So it's a tale, I think, of be careful what you're looking for. It has helped some families, and some families are very happy with the arrangements, but others did not understand the loss of rights and did not understand, what might happen to their child if they left the public school for one of these choice programs and it doesn't work out. So, what do you what have you been hearing is on the horizon? What are people trying to push for relating to the school choice, and what is COPA's agenda relating to that subject?
So the first thing I'd just like to reiterate what you said is that to date, all of these programs that you've mentioned are funded with state and other private dollars. Federal dollars have not supported any type of voucher program except for in the District of Columbia. So one of the things COPA is very clear about, is that we don't want federal education dollars supporting these efforts. There are too few federal education dollars available, as siphoning off any of them for these efforts, we believe for all of the reasons you listed, is not a good idea. If we have and give the opportunity for policymakers to start finding legislative ways to essentially snip these funds away from being considered federal dollars, and then the protections and rights and opportunities that come with the federal dollar are no longer available, that will not serve our children and our families well. We do not want that precedent set in federal law. So that's one thing we're paying close attention to. The vehicle that is most likely to move would come through the big tax bill that's being negotiated, and it would provide a tax credit to nonprofit entities that receive private dollars and then give these scholarships to students. A tax credit may sound innocent and not harmful, but somebody has to pay for it. And so, for example, Senator Cassidy's bill would propose $10 billion a year toward these tax credits and essentially create a loophole in federal law for how you fund, indirectly fund through a federal mechanism overseen by the IRS to support these scholarships or vouchers. So I know it sounds really convoluted, and it is. It is. But the bottom line is they also have to figure out how to pay for 10 billion new dollars in our federal budget. And while they can't directly say they're going to take that out of Title I or IDEA, because that sits kind of over on to the side because of the way our appropriations work, ultimately it will make less federal money available for many things, including education dollars for Title I and IDEA in the long run. And that is a major worry.
Great. Thank you. Well, I know for our listeners' benefit, I'll also explain that Laura does so much for COPA in the way of direct interaction with Congress and with the administration, but also with our members. So if these are topics of interest to you, if you want to learn more or keep abreast of what we're doing, we urge you to join COPA, to sign up for the Government Relations Committee. Laura provides them every week with an update, and she also does our weekly news for the federal government and also organizes our Hill Days, where COPA members go to D and meet with their elected representatives. And I believe that there's Hill Days coming up soon. Am I wrong?
That's right. May 5th through 7th in Washington, D.C. And we're actually going to have some information on that in our COPA news next week. So we hope as many of you that can come will come and help us go on Capitol Hill and talk about all of the issues that matter for students with disabilities and their families.
Great. Thank you. Well, we are going to have a future podcast episode where Chris Rowe, our state policy director, will come and talk to us about all of the different things that are happening at the state level. And that work complements the work, of course, that Laura and our team does at the federal level. So thank you once again, Laura, for being one of our guests today. We'll hear shortly from Ellen Saideman, who's a COPA board member and who works on legal issues on our Amicus committee, and she'll be here to talk about the Loper decision in just a few minutes. But again, Laura, thank you so much for being here today with us, and we'll probably, I'm sure, have you in to the episode in the future.
Great.
Okay, we're ready for our second guest today on the episode The Road Ahead, What We Know and What to Watch. We are fortunate to have Ellen Saideman, who is a COPA board member and who has decades of experience as an attorney for parents and students, and also at the appellate level. Ellen is one of the co-chairs of our Amicus committee and works with our committee to provide briefs for cases that are on appeal, as well as doing moot courts and other types of technical assistance. So welcome, Ellen. And if you could please tell our listeners a little bit about what brings you to this field and what your role in it is for COPA, what you see your role is for COPA.
Well, I got interested in doing disability rights when I was a young lawyer, and I worked at the New York City Commission on Human Rights, and it became clear to me that disability rights was an area of law where at that time, which was in the 80s, that employers and places of public accommodations had no compunctions about discriminating against people with disabilities and would admit to it. And I got very interested in that and then began working in that field. And see my role in COPA as helping COPA improve the law and assist people in using the law as effectively as a tool for social justice.
Great. Well, we're so glad to have you in that role and appreciate all the work that you do on COPA's behalf. The reason why you're a guest today, or what we're hoping you'll share, is a little insight into a recent Supreme Court decision that affects or could potentially have an effect on the implementation of regulations. We heard our previous guest, Laura Kaloi, talked about the difference between statute and regulation and typically how that works, including the fact that the administrative agencies under certain, who's ever in the office at the time have the responsibility typically for implementing regulations. But in 2024, there was a case called Loper Bright Enterprises and this was at the Supreme Court level, and it overturned what was called the Chevron deference doctrine. The case challenged the authority of federal agencies to interpret what are sometimes ambiguous laws. Can you explain for us what really might be the impact of this ruling, especially on IDEA cases?
I think that this case may have little to no effect on special ed cases. First, the Supreme Court hasn't ruled in a case of and applied Chevron deference since 2016, and they've been treating it pretty much as dead. So it has not really been applied by the Supreme Court for such a long time. Second, Chevron deference is an area of deference that they gave to agencies only when a statute is ambiguous. And there are many portions of the that are not ambiguous. So it would only come up if there was an agreement that the statute was ambiguous. And I think that one of the things that we need to learn from Loper Bright and other recent cases is one, it's really important that statutes be written clearly. And two, when we make an argument, we should first look at the language of the statute. Many of the ID regulations just repeat the language in the statute, and the statute is what's passed by Congress. And that's what matters most. The other thing that's important to know is that IDEA was what people were very concerned about how the president would implement IDA in the early 80s. And Congress passed a law which basically says that looking at any regulation involving IDA that was in effect in July 1983, you cannot, the Department of Education can't change the regulation to be any less protective of student rights. So that means pretty much that if the regulation was enacted in 1983 or earlier and enforced at that time, then it's pretty much has the force of a statute, and Loper Bright wouldn't apply at all. And this came up in a case some time ago in the Fourth Circuit about IEs, and the school district there had challenged IEs and said that the Department of Education went too far in requiring school districts to fund an IE because the statute doesn't say anything about school districts paying for IEs. The court in that case said, well, they may not have said anything in the statute, but the Department of Education said it in a regulation, and that regulation was law in 1983. And therefore, because Congress pretty much made it a statute, it is enforceable. So the first question is going to be, was a regulation in existence on July 20th, 1983? Now, obviously, the Department of Education has enacted many new regulations since then. But what the Supreme Court said in Loper Bright is we're not going to apply what's called Chevron deference, which means that if a regulation is ambiguous, we'll let the Department of Education or any administrative agency do whatever they want, pretty much. Instead, what we're going to say is that you have to apply a different level of deference or give it respect, because there's a case going back to, I think, the 1940s called Skidmore, where the Supreme Court at that time said that the agencies know a lot about the facts and about applying things. So if if the agency has made an interpretation and it's reasonable, you should respect it and go with it. So because so many of the issues that are IDA are very fact driven, and because the agency obviously has a lot of experience in implementing IDA and investigating it, I think that many of the questions are going to be resolved by Skidmore deference. And in fact, if you looked at, I did a little look myself, the cases that have applied Chevron in IDA cases. And first, there were only a handful of cases that applied Chevron. And two, the parents didn't always win when they applied Chevron. In fact, I was talking to a lawyer talking about employment law, and he said his understanding of the rule was that Chevron deference applied if the employer won and didn't apply if the employee won. So it was no big loss in the employment.
Okay.
So I don't think that it was really applied in any important case in IDA. And I think that what the courts have done in the past is said, well, we're not going to get to Chevron deference unless we see if Skidmore deference works and whether it's reasonable. And since most of the regulations are reasonable, they've prevailed. So I would not worry about this in the special ed context.
And to be clear, the last time that the IDEA regulations were issued was in 2006 after the 2004 amendment of the IDEA. So what I hear you saying, and tell me if I'm correct here or if you want to clarify, but is that, certainly anything that was in the 1997, probably, or I forget what time, when the regulations came out. They came out in 97 because the law was passed in 95, right? So those are covered by that 1983 rule that you were talking about, or the
No,
law,
no, the
whereas the
1980,
2004 would not be?
the 1983 only applies to the regulations that were in effect in 1983. So
Okay, not before that. Okay.
any subsequent regulation, you would have to ask, is this reasonable? And should we
Okay.
give more deference? And I think that because of the level of expertise the Department of Education has, I think that it would apply. I would say that many times the regulations, many of them will have been reissued, the regulations from 1983. So what you need to do would be to go look at the 1983 regulations and compare them to the 2000 and regulations. And if they're identical word for word, then they are passed by Congress as
Okay.
statutes and have that effect. So you just have to look at the language. If it's something new, um, let's say there was something about Zoom, which obviously didn't exist in 1983, then you would have to say, is this reasonable?
Okay. So they would still have to file in the court to make a claim that they didn't think that the regulation was reasonable and give their rationale for that. So
Exactly.
it's not just that.
All the regulations are entitled to are enforceable until such time as a court finds that they are not reasonable and and that the court thinks a different interpretation of the statute requires a different outcome. But I understand that there are some people who've heard from school districts that the regulations aren't effective. They are the law until a court says that the regulation is invalid.
Okay, great. So that's parents and advocates. We know that there has not been a challenge to those regulations in the courts as of yet. And so as of today, they are still the law of the land and need to be implemented. Is there
Absolutely.
what would you say is a key takeaway then for parents and advocates on this and attorneys on the issue of Loper and the Chevron decision?
I would say I would argue that it was irrelevant to any case that came up under IDA, because I would say that, first, was the same language as a 1983 reg. In that case, it's a statute and it's clearly the law of the land. And if it is not, then I would say, well, I would look at this case and evaluate it in light of Skidmore deference. And in light of Skidmore, it's a reasonable construction and it's entitled to respect and should be considered the law of the land. But the thing that's most important that I want to emphasize is this is something that COPE is very interested in, this issue, and that if this argument comes up in any cases that people are working on and school districts are making this argument, they should reach out to COPA, because I think that we want to squelch this before it goes anywhere. And so this is something we're happy to provide technical assistance on and to work with people on as an issue, because I am concerned that informed school districts are going to be things that are violative of parents' rights under IDA. And because parents are unaware that Loper Bright shouldn't make any difference in the law for IDA, they may not be able to resist the school district. And so they should contact us for backup support.
Great. And you said earlier when you first came on that part of your role and part of the role of COPA is to protect the strength of the laws, or to build them, make them stronger. And so providing technical assistance in this way, using the interpretations and the guidance that you've just provided in terms of those key words and the key cases to cite, can help do that. So that's a great reminder. Thank you. All right. Well, thank you so much, Ellen, for sharing your expertise with us today. As we wrap up today's episode, I want to remind everyone that advocacy starts with us. COPA's primary mission is to protect the legal and civil rights of students with disabilities and their families. We absolutely encourage you to join us, to get involved, to stay informed, and let's navigate ed together.